In case number 1509, U.S. Bank National Association versus the Village at Lakeridge, Justice Kagan has the opinion of the court.
This is a case that only an appellate judge could love, or maybe even be interested in, because it's a case about how appellate judges review the decisions of lower courts. The context isn't very important. It's a bankruptcy case, and the ultimate question is whether a bankruptcy plan should be approved. But that's not what we decide here. A significant factor in figuring out whether this bankruptcy plan should be approved is whether one of the creditors counts as what's called an insider of the debtor. But that's also not what we decide here. The courts below thought that one way of answering that question was to ask whether the creditor and the debtor had transacted at arm's length, that is, as though they were strangers, or instead had engaged in a kind of sweetheart deal. But we don't decide that question either. The only question we decide is how an appellate court should review a trial court's finding that a transaction was at arm's length. There are two options. The appellate court could give a good deal of deference to the trial court's decision and reverse only if it's clear error. Or the appellate court could start fresh, essentially ignore the trial court's finding and do the thing all over again. And here's some background that's helpful to answering that question. There are really three kinds of decisions courts make. First, sometimes they decide factual questions: who did what, when or where, how or why. Appellate courts give lots of deference to trial courts as to those issues. The idea is that trial courts have lived with the case a while. They know all the evidence. They've seen and heard the witnesses. Appellate courts should respect that and keep their hands off unless there's a glaring mistake. Second, sometimes courts decide pure legal questions, what the law requires irrespective of what the facts are. And as to those sorts of issues, appellate courts are the masters. They're the ones who get to expound the law and say what it means. Third, sometimes courts decide what are called mixed questions of law and fact. In other words, they have to decide whether a set of facts satisfies some legal test. So let's say it might be that everyone agrees on the facts and everyone agrees on the legal test, but still they may not agree on how the test applies to those facts. And that's the sort of question at issue in this case. As to those mixed questions, it's sometimes hard to figure out whether district courts should get deference or instead appellate courts should be in control. What we say in this opinion is that it depends. Some mixed questions really require courts to further elaborate on the law, to develop legal principles for other cases. Others, more immerse courts in case-specific factual issues, require them to do a deep dive into the witnesses and other evidence. If there's lots of legal work to be done in deciding a mixed question, the appellate court should decide the matter itself. But if the work primarily involves weighing evidence, then there should be deference to the trial court. Here, we say deference was appropriate. The question, again, was whether a particular deal between a creditor and a debtor counted as an arm's-length transaction. That required a court to look at all the evidence and decide whether the contracting parties were acting like strangers. It didn't require a whole lot of legal knowledge or work. So we think the trial court should be the primary decision-maker and the appellate court should defer to its judgment. That is what the appellate court did here, and accordingly we affirm. The opinion of the court is unanimous. Justice Kennedy has filed a concurring opinion. Justice Sotomayer has filed a concurring opinion in which Justices Kennedy, Thomas, and Gorsuch join.